As Southern California Edison discusses a compensation fund for residents affected by the Eaton Fire, people in Altadena and Pasadena are weighing a stressful question: accept a quick offer or wait for a case-by-case resolution through the courts. Caution: utility-run funds have historically paid 20 to 30 cents on the dollar compared with negotiated settlements in litigation. Such programs are typically take it or leave it and can pressure families to accept less than the total cost of rebuilding their lives. Fewer than 5% of eligible claimants in prior fires have opted into similar funds, describing them as a carrot on a stick that delays full individualized settlements. What being made whole entails, according to a wildfire attorney: 1. Rebuild costs at current market prices, not a low per square foot figure. 2. Mature landscaping trees, shrubs, and grading, which can total hundreds of thousands of dollars. 3. Personal property at fair market value, not a depreciated or capped amount. 4. Alternative living expenses, long-term housing, meals, incidentals while displaced. 5. Loss of use of the home and property over months or years. Attorney's fees and litigation costs, which should be compensated in full in a true settlement. 6. Interest for the time families wait to be paid. Emotional distress, including the evacuation experience and loss of irreplaceable mementos. Fund versus litigation: what changes for the survivor? Compensation fund: a formula-based offer with limited categories, typically presented as final and not tailored to individual circumstances. These offers are often materially lower than individualized settlements. 2. Litigation settlement protocols: file a claim, exchange evidence, and pursue mediation or binding mediation with trial as a backstop. This process allows experts to document the full cost to rebuild and restore the property and life disrupted by the fire. This is how families are made whole. Questions to ask before you sign anything: 1. Which categories are covered and how are they calculated? Rebuild costs at today's prices, landscaping, personal property at fair market value. 2. Are alternative living expenses and loss of use included, and for how long? 3. Are attorney's fees, expert costs, and interest covered? If not, how are families made whole? 4. How are emotional distress damages handled? Evacuation hardship, loss of cherished items? 5. Is the offer negotiable or truly take it or leave it? What is the appeal process? The bottom line, for now, wait for specifics and get independent advice before opting in. Utility-run funds can leave families with only a fraction of their total losses covered. Less than 5% opt-in rates reflect that reality. Survivors are now being asked to trust SCE, but this is the same company that reported nearly $1.7 billion in profit in 2024 and billions more in previous years, all while knowing it had caused some of California's most devastating wildfires, including the 2017 Thomas Fire and the 2018 Woolsey Fire. Instead of investing those profits into critical safety measures, SCE failed to take the necessary steps to prevent the Altadena fire. Speed should never compromise justice. When you need answers, Bridgeford, Gleason, and Artinian is there. Our team works tirelessly to prepare your claim and maximize your recovery. In past cases, we've rejected offers from utilities and obtained settlements 2 to 3 times higher than what they initially offered, even after attorney's fees. If you have been impacted by this wildfire, don't settle for the minimum. Contact us. We're here to help you get what you deserve. Fair compensation earned through hard work, not shortcuts. Let's stand together for justice, for your community, and for your future.